So they weren't deliberating for very long, just a few hours or so.
Right, exactly. The case it got around to the idea of, did Apple make these changes to kill their competitor or to improve the product? Apple argued for the last couple of weeks that they did this to improve security, that the record companies they dealt with for iTunes were requiring them to make these changes because of concerns over hackers.
You had the plaintiffs saying the changes that Apple was making were like a candy bar, an addictive candy bar, and customers just had to keep coming back. But here it seems that the jury quickly decided that Apple didn't do anything wrong. What do you make of how quickly this verdict was returned?
Yeah, they were in court for a couple of weeks, and the plaintiffs' lawyers even lost some of their plaintiffs at some point because of various reasons. And it was a complicated case that they were trying to make, this idea that these changes were made to hurt a competitor that a lot of people weren't even really that familiar with.
It's interesting. This is a case that dates back like 10 years. What are the real implications for Apple today?
Well, one of the big issues was going to be how much, if they were found guilty, would be liable, and that was going to be upwards of $1 billion. But really, this was also just a kind of a black eye for Apple. The plaintiff was able to get video deposition of the late founder of Apple, Steve Jobs, and that was something the company really did not want to be shown in court.
Tell us more about that video. What did we see in that video? What did Steve Jobs have to say?
It was about 6 months before he passed, and he's on this deposition, and he is thin and talking hoarsely, but he said almost 30 times he didn't really remember this issue back in the day. But he also was defensive of the company's position. They were concerned of hackers.
So how much does this actually impact Apple now? I mean, is it still a black eye? They've won.
Right, they've won, and the other issue is the technology that we're talking about from back then is no longer not being used in new iTunes songs.
All right, Tim, hang on. We actually are joined on the phone now by William Markham, a San Diego antitrust attorney. William, I know you've been following this case very closely, so what do you make of the fact that in just a few hours the jury has come back saying Apple did nothing wrong?
There's an old adage about litigation, which is that an appellant is often the party who made things very complicated at trial. And sometimes a jury is obliged to endure an overly long, needlessly complicated trial, and at the end they have not been persuaded. They might have been bored and just didn't grasp what it was the plaintiffs were trying to say.
Do you think the plaintiffs had no case here?
No, I think they actually had a good case, but what the antitrust laws require them to state clearly and compellingly is that Apple introduced this revision to its software not to improve its offerings or to offer security, but simply to make it impossible for competitors to sell music that could be carried on its platform, and that it did so to try to establish and preserve a monopoly position in its market, which would be the sale of music that can be played on these iPods.
Now, I've been speaking with our Bloomberg News Apple reporter, Tim Higgins. I'll ask you the very same question I asked him. Even though Apple has won here, how does this reflect on Apple today and going forward? Is this still a black eye on the company?
Oh, you're asking me. I'm sorry. Well, I don't think this case. I think this is a victory for Apple, but Apple is involved in another case, the ebook pricing case, in which it was found liable at trial, and this was in New York, for conspiring with the book publishers to fix and raise prices for ebooks. And so I don't think Apple has emerged as an altruist or competitor that does not engage in antitrust abuses, but clearly it's a good day for Apple that it has not been found liable in this case.
Apple has also faced a series of patent challenges from companies like Samsung. You mentioned the ebook pricing trial, and even though that they have won today, would you say there appears to be something wrong with the way that Apple does business from a legal perspective?
That's a great question, and I think it's not just Apple. There appears to be a distinct business culture in the Silicon Valley, and many Silicon Valley companies somehow seem to think that they're immune from from the antitrust laws, from ordinary laws of business valuation, and from other business precepts. And it's not just Apple, and even more spectacularly, there's the Uber company, and there was the employee poaching case, which involved all of the big companies in the Silicon Valley, or seemingly so. And so I think Apple's conduct does raise serious antitrust concerns and other concerns as well, and it seems to be characteristic of a certain business culture that we sometimes see in the Silicon Valley.
But what kind of recourse will there be for actions if indeed they are not above board?
Well, it depends on the particular conduct, but I think that the Department of Justice and the state's attorneys general and private litigants have successfully pursued Apple for coordinating a conspiracy to raise the prices of e-books. And Apple has made that they aggressively enforce their most favored nation clauses to try to raise prices of different products. And I think we've seen successful actions challenging that. And the best remedy, though, is that perhaps within Apple, the directors and officers of the company will say, we don't need this bad publicity. We don't want the expense of all of these different antitrust actions. Let's make sure that we're not engaging in conduct that appears to subvert competitive processes and that whose principal purposes seem to be to undermine our competitors, not improve our offerings. And that's the hallmark of antitrust.
How much of this, William, is the responsibility of Tim Cook? A lot of these cases date back to the days when Steve Jobs was in charge. Now that Tim Cook is in charge, do you expect things to be done differently?
Yes. It seems to. I think that Steve Jobs was a visionary. He was an inspired designer. He had extraordinary insight into how he anticipated markets as no one else seemed to be able to do. But he also seemed to lack an intuitive grasp of what kinds of conduct would be could be easily characterized as blatantly anti-competitive.
All right, one last question for Tim. One last question for Tim Higgins here with me in the studio. What's next, Tim? What are you watching? Any other legal issues?
Yeah, we're going to be watching the e-books, definitely. But this case is really a good example, a window into what Apple was like, a decade ago when they were the underdog. These record companies were willing to deal with Apple because they were not the behemoth that they are now. And so we're seeing kind of the evolution of the company over time now. Now they are the world's largest, but back then they were the underdog.
Are you saying then they're going to behave differently, or they already are behaving?
You're starting to see that with Tim Cook. He's being more open, his communication style than Steve Jobs was.